Hi, so I wanted to welcome everybody today to our Stein Sperling's Personal Injury Seminar number 3. Today, I'm going to be speaking. My name is Fred Balkin, one of the principals in the firm, along with our senior counsel, Jonathan Lieberman, who will also be presenting as well. So welcome today to our seminar series number 3. Which is entitled Use of Medicare Rate Scheduling when Auditing Chiropractic and Therapy Charges. Recently, we have noticed that insurers have started to arbitrarily reduce chiropractors' medical charges using Medicare rates. And the seminar is really going to go through what you can do as a chiropractor and or physical therapist to really fight back on this arbitrary practice and how you can help your patients by doing so. Recently, we are seeing a new attempt from auto insurers to mitigate what constitutes reasonable and necessary chiropractic charges and physical therapy charges. Some insurers are asserting that chiropractic bills should follow Medicare reimbursement schedules, even though Medicare pays a very low rate for chiropractic and or therapy visits. On average, we're seeing Medicare rates somewhere around $30 to $40 a visit. And we're also seeing a cap on the amount of therapy that can be provided actually over a 12-month period, which at times can be as little as 20 visits, and that's over an entire year. So clearly, this is a very important topic and something all of us in the industry, whether it be the personal injury, legal industry, and or the chiropractic, physical therapy, medical provider side, need to really address. John?
Thank you, Fred. So our firm, we're under the opinion that the goal of this trend that we're seeing from the auto insurance carriers is to substantially lower the amount of first-party, what we call PIP or personal injury protection benefits, and or MedPay benefits that are regularly paid out to chiropractors, physical therapists, or their insureds, and to also limit the amount of care that each patient or client of ours receives. And the results of all this is really a financial windfall for the insurers, but it also potentially affects the ultimate pain and suffering settlement and or judgment that we get on the legal side. This is also accomplished by the insurers greatly reducing how much or the duration of care and limiting the economic damages, which in turn limits the accident victim's ability to claim ongoing pain and suffering. It also affects any claim for permanency and or need for future care because it's limiting, or the argument limits the duration of the treatment, and it also prematurely claims that an accident victim has reached maximum medical improvement. And so the good thing is, and why we're here today, is to go over things that chiropractors, physical therapists can do to combat these tactics and to ensure that you are all fairly paid for your medical services, and that the patient's ultimate satisfaction with both your office and your services and the settlement or judgment in their case remain positive. We have seen very often throughout the years that patients will not return to a chiropractor or physical therapist and or refer other people if they're unhappy with the case experience and their ultimate financial outcome. So first, we wanted to just go over what does reasonable and necessary mean. Now, Medicare has its own definition of it, which we won't necessarily go into right now, but courts generally use the plain meaning of these words to define these terms, okay? So it's really something or a treatment that is medically necessary and is a generally accepted procedure or treatment for a particularly diagnosed condition. Okay, so the question that judges or courts ask themselves are: is there a basis or a diagnosis that warrants the treatment provided, and is the treatment provided or equipment used, if it's a treatment that or modality that requires equipment, accepted within the chiropractic or physical therapy industry? okay? The definition is really the same for both, okay? So to be a necessary medical service, okay, for example, in the Maryland Personal Injury Protection Statute, it states that a service should have a efficacious material value, okay, of its own as a diagnostic aid is related to a patient's condition, okay, and that its use should be generally accepted, okay, in the chiropractic or physical therapy injury. So let me give you an example. So as a chiropractor, if you diagnose that one of the bones in the spine, right, a vertebrae or a bone is out of position, okay, then the general treatment or modality provided is a manual manipulation or an adjustment to correct what is called a subluxation, okay? So this is an example of a reasonable and necessary treatment or care, because it's a diagnosis. It is a common condition from an accident. It's being treated. There's a diagnosis, and it's a generally accepted treated procedure to help the healing or help treat that diagnosed condition, okay? So what is an example of something that may not be covered? So for example, cold laser therapy is something that's relatively newer, we know, to the industry, but it's not been 100% accepted necessarily as an accepted procedure, except for certain areas, okay? So if that is something that is regularly employed, okay, during treatment for injuries from an automobile accident, that's something that an insurance carrier may very well not accept, and or a court may not accept, because the insurance carrier's attorney is going to be arguing that that was something that was not necessary, that was not reasonable for the diagnosed condition, okay? Also, the idea is that if there is something else that can treat that condition that is more generally accepted or more commonly used, okay, then the insurance companies have a stronger argument to a court and to us that this is something that shouldn't have been employed in the treatment of that individual, okay? Now, support for treatment, okay, as to whether it's considered reasonable or necessary can only be done by the provider, okay? So the idea being is that it can't be done by the injured victim. It can't be done by the attorneys, okay? It can only be done by the provider, which is why we're going to get into shortly. Your records and bills are so vital, okay? And the information that you put in them is so vital. Most soft tissue injury cases in Maryland and Virginia go into the district courts. In the district courts, there are rules that allow the judges to rely solely on records and bills as evidence of reasonableness and necessity, okay? And as they make their determination, okay? So, and we've covered that in other seminars that we've done, but we wanted to bring that up again. So that's another reason why we really want to focus on what you're putting into to help you combat what the insurance companies are doing, okay? Now, another question we get is, well, why should your treatment modalities and billing rates be consistent with other chiropractors and or physical therapists in your region and accepted by industry standards? What provided spark really for this seminar is this new tactic that insurance companies, auto insurance companies, are making the argument that Medicare rates should be the basis for how much you should be reimbursed as a chiropractor or physical therapist from an auto accident case, okay? Now, there's no law allowing this or rule of court that permits them to do this. They just decided this on their own. And they're using this to arbitrarily lower the acceptance of the amount of bills and or treatment in cases, okay? And as Fred mentioned earlier, Medicare covers only generally 80% of the allowed amount their allowed amount per visit, okay, which we know is not the billing or the rate that you're billing per visit, okay? And they normally cap the number of visits a person can even have in a year's time. Usually it's around 20, depending, okay? And as Fred mentioned earlier, this effectively works out to a $30 to $40 reimbursement per visit. So what the carriers are doing is they're arguing that you should be charging either that or a small multiple of that in an auto accident case, okay? So again, to combat this, what can you do? Well, one thing is you can show that your billing rates are within the industry standards and that the amount of care is specifically justified by the findings and diagnoses in your reports, okay? So for example, if there is a dispute as to the charges in the bill, okay, whether it's pre-litigation or in court in litigation, okay, if you as a provider can show that these charges are in line with other similarly situated practitioners in the greater DC metropolitan area in our region, then there's a much greater likelihood that a court is going to accept the bill ultimately, okay? To give you an idea of what we see in our cases, and again, this is just an average of across different practitioners, we see an average bill normally of about $261, okay, give or take. Many of the carriers, they tell us when we're trying to negotiate a claim that they will accept $200 a visit for therapy, okay? So even though that 261 may be arbitrarily cut in negotiations, okay, there's a good chance ultimately that if you can show that your bills are around or in the same general vicinity of the average, that a court will likely not cut those bills, okay? And the same argument goes for treatment modalities. So similarly, what are the likely course of care? What's the likely course of care used for injured accident victims, right? Three common ones we see: chiropractic manipulation therapy or adjustments for subluxation, as we spoke about earlier. We see therapeutic exercises, electrical stimulation, and those are three common ones that we see, okay? So if you do normally or plan to use modalities that are not generally used, okay? And of course, what I mentioned is not the only ones, but if you're using modalities that are not commonly used in the industry, or if there is a more common alternative available to treat that diagnosed condition, these are treatment and charges that a carrier will argue are not reasonable or necessary, or that the charges should be stricken and ultimately not considered by a court. The final question that I want to answer before Fred takes over is, why are interim therapy notes or narratives necessary? So an interim therapy note, or what is likely usually called a re-examination report or a re-evaluation report, is very important, okay, when combating insurance arguments in our cases, okay? So for example, they explain the medical care in detail, including pain and suffering. And Fred's going to speak about that shortly. They also help to establish and continue the support, okay, during the course of care of the causation of injuries. So the legal standard in our regions are reasonable degree of medical probability that an injured victim's injuries were directly related or whether they aggravated a pre-existing condition. Okay, so a re-exam or re-evaluation report supports that. Okay, it supports that you're indicating that the victim's injuries are still related and continue to be related to the accident. Okay, basically, when you as experts, as doctors, your opinions have to be based on probability and not on possibility. Okay, and again, how do you determine that? From the facts. So the more detail you can put in your reports in a re-examination or re-evaluation report, okay, the better, because those facts are going to show, they're going to support your opinion that a victim's injuries were related to the accident. And again, insurance carriers are going to look at that, and courts are going to look at that as well. Okay. So, as we spoke about earlier, reasonableness comes down to you, the medical provider. Okay. So it's your opinion that counts, as we like to say. And it also, what these interim reports, is they provide additional support to any of your diagnostic billing codes. And I think what we've seen most importantly, it helps us combat or defend against the carrier's arguments of the length of care, meaning their care is taking too long, or whether your treatment has been helping or assisting in the progress of healing in the injuries. Okay, this is, again, arguments that we see quite often, okay, not only pre-litigation, but in litigation, that, hey, this person had a back strain or a neck strain and it took too long, okay? So the interim report is vital, because if you re-examine someone, let's say 3 or 4 weeks out, and they're still that injured victim is still showing signs of pain, restriction of motion, things that can support your diagnosis and the treatment you're continuing to give, that's what the courts especially want to see. Okay. Carriers like to audit reports and say that someone with a back strain, for example, or a lumbar strain, should have had treatment and resolved in a certain number of weeks, 2 weeks or 3 weeks. Now, we here all know, right, that everybody is different, right? And to say that is just being arbitrary across the board. But a good detailed re-exam or interim report is going to help support the ongoing care and combat this argument by the insurance carriers. Fred?
Thank you, John. I appreciate that. Again, I really want to follow up on what John's saying, and I'm going to give you some ideas on really, how do you combat this new effort by the insurers to mitigate medical charges and treatment. And I've always harped and lectured everybody I have the opportunity to talk to that good medical documentation is absolutely essential. And that's the weapon that needs to be used to fight this. And the first suggestion, and it's interesting because I don't see this a lot in the chiropractic and therapy notes that I receive on a daily basis, but there isn't something often that's mentioned, which is what we call pain and suffering. Each chiropractic and or therapy report, not necessarily the physical therapy notes themselves, but the initial, the interim, and the final report, for example, should always have some mention of the patient's pain and suffering. There should not only be mention of the specifics and the severity of the pain the patient is having and where it is located, but further how the patient's pain and discomfort are affecting his or her everyday life. The best place to put this, in my opinion, in the records is most likely at the beginning of your medical report when you're discussing the subjective complaints. I recently saw an example of this from a medical practitioner, and it's so rare, I actually took note of it, but I'm going to give you an example of what this practitioner wrote in general. So this practitioner wrote, quote, "Patient comes in today reporting acute pain." Now, again, I've always suggested to avoid the pain scale if you can do that. And says, throughout his neck, shoulders, and back, which is persistent throughout the day as well as the night, and which hinders his ability to participate in his daily life activities, which include household chores and childcare. At night, patient reports he has trouble sleeping due to his spinal pain and his inability to find a restful position. Patient reports he was unable to attend his friend's wedding this past week due to his inability to stand or sit for long periods of time and his general bad state of health. So that's kind of an example, and you can do it any way you want. You can do it, in a less verbose way, or you can do it, put it any way you'd like to put it. But that's an example of a typical mention of pain and suffering prior to the examination. The chiropractor documented pain and suffering. By doing this, helps both the insurance adjuster and the jurors, for example, to understand why the care rendered and the duration of same was reasonable and necessary, what John was talking about, and why the charges billed for were justified in light of the quality of care which was provided by the practitioner. So when an insurance adjuster or a jurist is looking at something like this, when they're reading your reports, it really helps show a much higher level quality of care when you take the time to really show that you spoke to the client, you obtained this information, and that you're basing ultimately, in addition to your findings, the treatment based on what was said here. It's very, very helpful in defeating arguments that the charges are just way too high and unreasonable. Documenting the acute nature of the injuries, when you do that, the patient had and the suffering they endured during the treatment period, again, is very, very important. And chiropractors showing quality of care and why they thought the treatment was justified based in part on patient discussions and the description of subjective complaints, again, is extremely crucial in these cases. There's another big area that we run into a lot in these reports, which also lends some credibility and basis for insurers to make arbitrary, baseless arguments about the appropriate nature and the amount of care rendered, and that has to do with compliance of care. Compliance of care is probably the #1 defense we encounter when negotiating or litigating chiropractic involved accident claims. One of the biggest ways to defeat insurers claiming the treatment was not reasonable and it was not necessary is to show the treatment rendered by chiropractors and or therapists was consistent and that the patient followed the treatment plan and did not haphazardly attend therapy appointments. Insurers always first look for consistency of care and compliancy with treatment recommendations. It really is up to both the treating chiropractic office and the attorney to both ensure treatment consistency. Chiropractors should be emphasizing this to patients at every visit, as well as lawyers during their discussions and or meetings with the client, and there should be a fluid communication between the chiropractor and the lawyer if there is an issue that is noticed. Chiropractic charges are more likely not to be found reasonable and necessary if there is a complacency and compliancy with treatment plans and protocol. Patients that miss appointments regularly and whom do not follow treatment regimens as directed by the practitioner frequently are in treatment longer. They complain more about the lack of rehabilitative progress, and they really kind of severely damage their credibility when it comes to pain and suffering. So compliance with care and ensuring regularly that patients are compliant is absolutely crucial in this battle that we're involved in at this point. I want to talk about a third issue that comes up a lot, and that has to do with malingering. Malingering, or staying in treatment past maximum medical improvement without any basis for doing so, medically objective or subjective basis for doing so, is probably the biggest problem both chiropractors, physical therapists, and lawyers face when handling and trying to successfully resolve personal injury cases. And the basis for the insurance industry's argument that Medicare rates and limitations of chiropractic care should be adopted formally at some point. The argument is in part that the higher the allowable chiropractic charges and the greater the duration of care allowed, the more likelihood that malingering will occur. So again, these insurers are asserting, okay, that if they start accepting care past a certain point, we don't know what that point is yet, but let's say past an average treatment point where most people are discharged, then that means there's going to be a much greater likelihood that people are going to malinger. There's going to be unreasonable, unnecessary medical charges, and therefore someone's got to cap this. And that's been their argument. Malingering for chiropractors and therapists, as an example, is a really big issue for other reasons and many other reasons as well, which include but are not limited to medical charges being substantially reduced by adjuster and or jurists and result in often significant amount of the chiropractor's bills being written off as not reasonable and necessary, thereby resulting in uncollectible account receivables. Attorneys are affected in much the same way, with not only economic damages being drastically reduced, but pain and suffering awards that are not reflective of the patient's and the client's pain and suffering. The result is a very dissatisfied patient client, and the greater the likelihood that if involved in another accident, that patient client will simply take the quick, insufficient settlement offers being made by these insurers and seek self-directed treatment on their own. Combating the Medicare reimbursement rate argument and the consequences of malingering, as noted previously, is the job, again, of both the chiropractor practitioner and the attorney, in our opinion. The chiropractor needs to identify when the client has reached maximum medical improvement, as you all know is MMI, from his or her accident-related injuries, and promptly notify the attorney of this. That attorney can then meet with the client and show them, what the practitioner's recommendations are and encourage them to possibly get discharged from active care and maybe seek maintenance care, for example, with the chiropractor, if noted, and or the therapist, if noted by the practitioner as necessary and appropriate. The push to make Medicare rates as the standard for reasonable and necessary only gains ground if issues like malingering stop and become the exception as opposed to the norm. So the last thing I wanted to talk about is responding to medical audits. And recently, we have seen many chiropractors unwilling to respond to insurance audits and or peer reviews. It appears many chiropractors and or therapists, and as well as other medical practitioners, have lost sight of the fact that it goes with the territory in all candor, so to speak, that should a medical audit occur, which usually happens when PIP and or MedPay are collectible forms of insurance in the case, that the treating providers should be responding to medical audits and explaining why their charges were reasonable and necessary. Responding to audits creates a permanent record that the provider charged what he or she did in good faith, and that the charges are in fact justified. Further, it provides an additional weapon against the insurers attempting to reduce the economic damages on the back end of the case, and helps ensure the chiropractor's bills will not be reduced, and that large reduction requests will not be needed by attorneys due to insufficient pain and suffering and settlement awards. Further, failing to respond to medical audits is a clear indicator to both the adjuster and the jurist, for example, that the chiropractor, therapist, or medical provider chose not to defend their own charges. Therefore, they must be excessive, or to some extent can be justifiably reduced, such as using Medicare rates. So again, responding, taking the time to do that It doesn't have to be a multi-hour response, pages and pages long. It just has to be a good faith response in which the practitioner addresses the audit and just simply states why the audit is not correct and what again, emphasizes what the basis was for the treatment, using CPT codes, using the findings that both John and I talked about, in the reports themselves. Again, documentation, documentation. That's why all this makes a difference. So what I'm going to do now is I really want to encourage everybody to, at this point, ask questions. We covered a lot in a short period of time. And if you ask questions, we're going to answer them, but it also helps everybody at the seminar kind of hear different points of view. What questions do you have? Maybe there's questions things we haven't covered or we haven't been specific enough. So I want to take the time now to open up the floor to questions. They're going to be given to me, and both John and I are going to answer them. What you want to do, by the way, is you want to put all your questions in the chat. So we're just going to give people a couple minutes to do that. Question number one that we received is, how can I tell what is an average charge for practitioners in my area? I'm going to let John answer that.
Sure. Thanks, Fred. So number one, talk to friends, right? Talk to other practitioners in the area. The idea is that as a group collectively, these issues affect everybody. So while we understand, where people are competing and for business and things like that, the idea is that if the practitioners in the region can formulate an understanding or a group think basically on what is the average charge depending on industry standard and things like that for a certain procedure, that is something that's going to weigh heavily going forward for courts and for insurance companies as well. Also, Maryland Chiropractic Association is a great resource, for example, for chiropractors in terms of to find out, hey, certain codes and charges for those codes that are generally accepted in the industry as they get information from all over, from our understanding.
Thanks, John.
Sure.
Question number two that we just got is talking about interim therapy notes and narratives. The question is, how detailed do they need to be? Do they need to be typewritten? And do they need to have any mention of pain and suffering in it? So I'll answer that real quick. I frequently experience issues from insurers reviewing practitioner therapy notes stating, number one, that they can't read them. So number one, if you can type your interim therapy notes as opposed to handwriting them, I would encourage you to do that. It makes a better presentation. It allows either the adjuster and or the jurors to easily read them. I would just encourage that you do that. I had suggested with pain and suffering that it should be mentioned, periodically throughout the case. Another option that I think you could do is you could very, very briefly mention, pain and suffering, at the beginning of even each therapy visit. You could put one or two sentences in there, or you could elaborate more in both the first initial report or last report. So the answer is it doesn't necessarily have to be included in every single visit that you do with a client, although it is very helpful if it's shown that each time a patient comes to you that you're asking them about it and you're inquiring about it. So I hope that that answers that question. The next question we have is, how detailed do the pain and suffering notes need to be? Again, John, do you want to go into that a little bit?
I
It
could,
says, wait, the other
sure.
part of the question is, how vital is it to document previous accidents or injuries? Let's leave that. That's a good question. Let's leave that. Let's follow up this question with that question. But John, why don't you answer, how detailed do the pain and suffering notes need to be?
So as Fred stated before, just very briefly, as Fred stated before, you want detail in it. It's not about the quantity, it's really the quality, right? When it comes to your notes. So you want to focus on showing that person as an individual. Okay. So for example, if you're treating someone who is a construction worker, okay, and you talk to them about what they have to do on a daily basis, they're going to have a different type of pain and suffering, right, than someone who's working an administrative or desk job. So what we like to do here in our firm, because we're always asking clients to help document their pain and suffering, is look at what they do for a living and look at their family life. So in terms of detail, if you focus on one of those or both of them, which would be great, you know, and you can extrapolate from them how these injuries have affected those areas. Those putting details like that are so helpful, and really the judges especially love to focus on that. Just look at look at the patient as an individual and how these injuries are affecting them.
Okay.
And put it down that way.
The second question, which I think is a really good question, and I'll take a shot at it, and John, you can elaborate or add to it if you'd like, but how vital is it to document previous accidents or injuries? More specifically, if they occurred a long time ago, more than a couple years. So initially, I think it is very, very, very important and vital that that every medical practitioner, when they have a patient that comes in for the first time, really goes into previous accidents and injuries. Because what happens many times, even if it was a few years prior to the accident, what can happen, as an example, is, let's say the case goes to district court and there's a question, you know, raised or posed, which says, you know, gee, I was wondering if the doctor knew that this client actually had a serious accident involving the same body parts 2 years prior to this accident. There's no mention of it in the medical reports. I think it can surprise a lot of people. I can tell you, we as lawyers, we go very, very heavily into a client's medical history. We actually go back at least 7 years, because 7 years is the rule of thumb when it comes to indexing by the insurance companies. So they have the ability to index by the date of birth and social security number and or both of the claimant, and they can go back 7 years, and that would include both health insurance and you know, tort claims. So we are very, very focused on determining prior injuries and prior claims, so we don't have any surprises later. And I would suggest all of you do that as well. John?
Yeah, thanks, Fred. I wanted to bring out, particularly if you were that provider that treated the person for a prior accident or work injury or anything, it is very vital, like Fred said, to put that in there. And it's perfectly fine to add to it that, you know, if it was something, for example, 4 or 5 years ago, and to ask the client, well, how have you been since then, right? What's been going on with you? And if a person has been, and this is what we do, if a person has been prior to our accident, had a neck injury 4 years ago, but just prior they've been working full time, they haven't been in treatment for their neck. That's something also, that is good to document. And it's just good for you guys, as providers. I think it's good for you all to get as many details of the person's medical history, because I think that that's going to help you treat the person better and get them better sooner.
Thank you, John. The next question that I got, which I also think is a good question, is what should be our first steps in responding to an audit request? That's a really good question. And I'm going to take a stab at that initially. So the first response, or the first thing that the practitioner should do, when you get an audit, when there's an audit request, there's an audit made of your medical charges. In that audit, there is going to be a reason given why the bills were reduced, such as improper CPT codes. It could be unrecognized modality. It could be modality treatment modalities were in too close proximity to each other, or frequency. They're going to give you a reason. They're going to tell you on what basis they're auditing the charges. And the medical practitioner, what I do as a lawyer when I'm reading a letter from anybody too, I read it, I make sure I understand what's being said, and then I directly respond to the basis given for what's being asked of me. In this case, you would directly respond to the reasons being given for the audit. And again, it doesn't have to be a long, drawn out, a detailed response. It has to be a direct response to the points brought up in the audit. It should be done without, by the way, any anger or emotion or frustration showing in your response. It's just got to be a very to the point response to the direct points being made in the letter and reasons for the audit itself. So that's what I would suggest. The next question, which is a good one, talks about malingering and, how do I deal? It says, how do I approach the issue with malingering with a patient without being offensive to the patient or in any way suggesting that they're malingering purposely? And that's a really good question, because the reality is most people don't malinger knowingly or intentionally or purposely. They do it because they themselves are concerned that they may develop problems later, that maybe they haven't fully recovered where they need to be as a result of the accident. And it's also honestly because a lot of times they may not be getting the proper feedback from the medical practitioner. So the approach, as an example, can be, Mr. or Mrs. Smith, you're on visit, whatever it is, whatever number it is. I've conducted an examination. I've done, the testing I needed to do. And it would appear to me at this point that you've reached what we call maximum medical improvement, which is you've really recovered at this point, to the best point that we can get you to. You certainly are welcome, outside of your legal claim and your pain and suffering claim to come see me in the future for maintenance visits, which if you agree with this, which may help you or keep you at a level that you're at now so you don't regress. It can be discussions like that. But I can assure you that if you approach it in a way like that, nobody's going to be offended by it. And I would also urge you to make sure that the attorney is aware that you feel that the patient has reached maximum medical improvement. Because again, that's that communication that I had talked about, that there really should be between medical provider and the client's legal representative, the patient's legal representative, the attorney. So that's how I would deal with that. John, do you have anything to add to that?
Just one thing, yeah. Personally, what I've seen over the years is that people like the treatment. It feels good. A lot of victims and people in accidents have never, before they get into an accident, they've never visited a chiropractor or physical therapist, and they realize and they see the benefit of it. Not just with the healing, but with just regular maintenance. So as Fred talked about, so it is good to also discuss with patients, home exercise programs and things like that that can also help them feel good, down the road.
The next question, which is also a very good question, is there anything you both have seen that would likely trigger an audit? Yeah, there is things that we see that, and it's funny because the biggest thing that's going to trigger an audit is notes which are all look the same, which are either just scribbled during the treatment period where no one can read them, or notes which appear to be very boilerplate, okay, in which it looks like the practitioner is using like a boilerplate medical template and filling in the person's name, the frequency of care, but things like that. But, these adjusters, and I can tell you the jurists and judges, the judges involved in these cases, they've seen so many treatment notes in so many cases that they can tell whether the treatment is boilerplate or not. The notes are that way as well. And I think that's really kind of the whole gist of this entire seminar. If you get a message today from us, what you should not do and how you can avoid, Medicare rates becoming the norm in personal injury cases, the first thing you can do is lose all that and start writing your notes where you're treating the person as a patient, as an individual person, a patient. You're showing differences in the information being provided in a report, specifics about the person, specifics about their pain and suffering that we talked about, where you're showing a true effort to provide a very high level of care to every patient you see. That is rule number one, and the biggest way that you can avoid medical audits. You have to remember too that these insurers are getting and putting in a database information about many of the practitioners out there who are doing personal injury cases. They know frequency of care. They know what the medical billing rates are. If your rates are exceedingly past the average rate for care of practitioners in your region and area, and they know this, they have a database and they know what the average rate is. And if the average rate of care is, like John said, $261 a visit, and somebody's billing $580 a visit, that absolutely is going to trigger an audit. Okay, because what they're doing is they're plugging in all your records and notes and bills into a system which does somewhat of a peer review electronically and starts flagging practitioners and bills and treatment which are not within the norm, which seem to be excessive. John, do you want to add to this?
No, you hit it right on the head.
So as a matter of fact, I do want to say that the next seminar we're going to do, which is going to come up in series number 4, is going to be a discussion about the State Farm litigation now which is being pursued against specifically chiropractors that we're seeing and chiropractic practices, in which they're alleging civil fraud due to what they claim are boilerplate charges and diagnoses of people in accidents. And we're going to actually have one of our senior attorneys who litigated this case on behalf of a practice speak about it and tell you what went on in the case and the discovery side of things without being specific, of course, but giving you generalities, which all go back to how are these practices being flagged for lawsuits, and what is causing that. And you're going to see in that discussion that a lot of it comes down to practitioners generating boilerplate notes, records, and bills, which are all the same or which they allege are the same for different claimants who are involved in a variety of different types of accidents. So that's something that we're going to talk about, and I would highly urge all of you to attend that seminar. It couldn't be any more important, and it's a good follow-up to what we're discussing today. So I hope you all attend that seminar. We'll send the information out shortly when that's going to occur. But I want to thank you today on behalf of Stein Sperling, on behalf of Stein Sperling's personal injury department, and hope that you got good information today. I want you to know that John, myself, and our other attorneys here are available to answer any questions you may have. Even if it isn't our case, we'd be more than happy to talk to you in general. If you had a general question, we'd be more than happy to do that. We can't talk specifically about a case or treatment, but we can answer general questions you may have involving anything that we discussed today. We are available to try to help you navigate this new trend and the new trends we're seeing right now by insurers. So again, thank you very much for attending. We both look forward to seeing you in our next seminar.
Thanks, everyone.